Good morning. May it please the Court. I'm Robert Keegan, and with me is Cheryl Kimball, appearing on behalf of NSTAR Electric. Below, the Department stated that the resolution of this case turns on the answer to a single question. Did NSTAR Electric remove supply-related bad debt from its distribution rates when it implemented its 2005 rate case settlement? On reconsideration, the Department took specific evidence from the company on that specific issue, and that evidence on a uncontested basis, uncontroverted basis, demonstrated conclusively that supply-related bad debt was removed from distribution rates in the company's filing effective January 1st, 2006.
But Mr. Guberman says, no, that's not the issue. The issue is whether that removal was approved by the department. And he says it was not approved by the department, so whatever you did has no consequence.
Well, I would respectfully disagree that both the settlement was approved and, pursuant to the settlement, the company made a specific filing for effect on January 1st. It did two things. A, it changed the default service tariff to apply this rate mechanism for the recovery of default service, and it changed the distribution rates solely for the purpose of removing bad debt from the distribution rates.
So the rates went down as of January 1, 2006, and stayed down until May 1, 2006?
That's correct, and even stayed down after May 1, 2006.
But there was a $30 million increase.
There was a $30 million increase, but it was offset by a reduction in the transition charge.
Could
But the distribution rate, you're right, did go up by $30 million.
Could you look at the contract? Because the contract that you're relying on, the settlement agreement, that is the 2005 85 settlement agreement, everything pivots on whether or not that agreement can be construed to be dealing with that bad debt issue,
yes.
Right? Because you're basically saying you have to read that not just in terms of the Articles 2 and 3, but also in connection with all of the papers that were made exhibits to that. But when I read the text of that, I'm not seeing words like basic service rate or distribution rate. You know, it's not so clear to me that that tracks the language that is, that is at stake here.
I understand your question with respect to the text of the settlement, but the settlement is
because
not.
It has one thing being reduced, and it has another thing being increased.
Yes.
And I take it, and those are on the two dates that you're talking about. But what I'm saying is that the terminology employed doesn't track the terminology that you're using in your brief.
Well,
and I don't know if it tracks the terminology of the 2003 more general agreement reached with all of the different utilities.
I would just say you cannot look at the settlement as only including the paragraphs of the text. The settlement.
No, but you're saying that the paragraphs in the text are very clear.
I'm saying the settlement as a total document is very clear. And the plain language of the settlement in paragraphs 1.4 and 2.5 say that the exhibits that are attached here too and the tariffs that will go into effect as a result of the settlement are integral parts of the settlement. And the way the settlement is being given effect is through the change in the default service tariff, which is attached to
I grant you that, but what I'm trying to get at is what is it that those words mean in the text of the agreement itself, in Article 2, which talks about, some rate being reduced as of January 1 and some rate going up as of, May 1. And I'm saying that those terms puzzle me. They're not clear at all to me, that they relate to anything having to do with this. Forget bad debt, but you can talk about the more generic term that you use, such as basic service rate or distribution rate, and a base distribution rate. So am I making myself clear what is troubling me? That, there is something here that says something's going up and something's going down and it's attached to those dates, but I can't tell what it is.
I would agree that the terminology could be clearer. These are sophisticated parties entering into a settlement that deal with these kinds of issues all the time. Basic service rates and default service rates are used interchangeably, and they represent a portion of distribution rates. I would just say that the issue of bad debt recovery, supply-related bad debt recovery, had been under review by the department in DPU 0388 for 2 years. And the issue was resolved in July of 2005. And when it came time for rate case settlements pursuant to 0388, the rules were pretty clear. And it said in a company's next general rate case, if it removes supply-related bad debt, then here's what the following treatment would be. That was implemented in the Bay State case in November 30th of 2005, at exactly the time that this case was being settled under a negotiated settlement with the Attorney General. And so this was more in the nature of a compliance with 0388.
Well, Mr. Keegan, in terms of the settlement, the filing that was for the $89.9 million that then got settled for the $30 million has, I take it, a schedule or tariff that specifically deals with this supply-related bad debt, correct?
For the $89.3 million, yes, it had a proposal to deal with the bad debt issue, yes.
Then it all got settled for $30 million, right?
That's correct.
I guess what I'm having trouble understanding is, in the context of negotiating that settlement, the parties weren't talking about what was getting covered and not covered? I mean, I'm having trouble seeing why we are in the position of having to figure this out. It seems to me it had to be something that either was discussed, or how could you get here without this?
Could I just ask a follow-up to that? Because my understanding is that the DPU says it wasn't just, and then they said, well, maybe we made a mistake. And so why don't you show us at the reconsideration? We might have blown it. You know. Why don't you show us where it is? And then, and I don't understand the voluminous documentation you've provided, but they don't find it in there. And looking where you've asked us to look, it's not in there. So their conclusion is, okay, we've given you another chance. We don't think we talked about it. It's not in the settlement agreement. But show us where it is. And I'm not talking about the letter that they say later on interprets the data, but it's not there.
The issue was absolutely discussed during the settlement agreement because, frankly, were we not to implement the provisions of 0388, we would have had to say why we were not implementing them.
So
it was a fairly easy situation. So what did we do? We have the language in the default service tariff, and if you look at the default service tariff, I think it's page 369, you will see where the default service tariff actually contains the language on the bad debt and says we will now go forward and reconcile bad debt to the actual amount being provided. There are 3 other categories of expenses
So
there.
this default service tariff is what went into effect on January 1?
Yes. And one other thing went into effect on January 1, changed rates. And the only change to the distribution rates were to make sure that the exact amount of test year bad debt was removed from those distribution rates. And if you read Mr. Lamontagne's testimony, where he goes painstakingly through what the settlement was in 0585, he shows that the settlement did, in fact, in the documents to the settlement, demonstrated that test year bad debt was $7,946,000. He tells you exactly how he derived the factor that the rates needed to be changed to remove that exact amount. Then, after the settlement was approved, we gave them the new tariff with the factor that they then approved. And the sole purpose for that change in that rate on January 1st was to remove supply-related bad debt.
You're saying the DPU, and more particularly the Attorney General, has changed her or its or her tune between approving the settlement and when you came forward with the...
That's absolutely the case, and if you read Mr. Lamontagne's testimony, you will see exactly how the settlement agreement provides for the removal of supply-related bad debt. I would only say the commissioners and the individuals on the commission at the time when 0388 was approved, at the time when the settlement were approved, is a different set of individuals from the commission that issued these rulings in 07-04.
But can you explain then, why do we have something like a 1,500-page record appendix instead of a 2-page record appendix that contains just page 369, the default services tariff? Why wasn't that the end of the story?
Well, because it's not just the default service tariff. It is the fact that we can show exactly how supply-related bad debt was removed from distribution rates. And that's the fundamental question, as the department says in its orders on this case. Did you, in fact, remove it? We presented detailed evidence showing that we removed it. In the department's order, it doesn't discuss any of that evidence. It doesn't go through it barely mentions Mr. Lamont's testimony. It doesn't talk about what the January 1st change was to distribution rates. And that, the sole purpose, the department is essentially saying, we approved a change in rates. We don't know why we were approving it. Because the sole purpose for changing that distribution rate was to remove supply-related bad debt, which was in accordance with the requirements of 0388. I would point out, 15 days, on December 15th, Fitchburg Gas and Electric filed...
What year are we talking about?
2009. The case came before this court on this issue. On December 15th, 2005, Fitchburg filed, consistent with 0588, a change in its default service tariff. Did the exact same thing. Provided for the reconciling recovery of supply-related bad debt. When the case, and it did it by stamp approving the tariff. The Attorney General in Attorney General versus Department of Public Utilities in 2009 appealed that and said, this is a change in the rate. You can't just stamp approve that. We need to have a hearing on that. The department's position in that case was, oh no, this is all resolved by 0388. We don't have to have a hearing. There's no issues in controversy. So it was fine just to stamp it approved. We needed no process. The court came back and said, well, no, you can't just change your rate, and it upheld the Attorney General's appeal. But the important part of that was the department at that time, basically treated this as a resolved issue and as a compliance. And that's why it's not really discussed in the textual portion. There was no case in controversy surrounding its implementation.
How can you say that the sole reason to change the rate was to remove the bad debt when if that was the sole thing that you did, you'd be dropping your prices for transmission?
Would be dropping?
You'd be dropping the prices. You'd be taking the bad debt out of transmission and moving it to supply. So if all that you did was to take away the cost involved in bad debts, you would be calling for a reduction in rates.
And that's what we did on January 1st. The $30 million increase that was settled upon didn't go into effect until May 1st. That was another change to the distribution.
Totally independent.
Totally independent. We resolved the bad debt issue and got it out of there first, so that this mechanism could be approved. And I would say this is a rate mechanism that is currently in effect for every other gas and electric distribution company in the Commonwealth of Massachusetts. This isn't something new. NSTAR Electric is the only company that is not currently using this mechanism.
You're using it. It's just that you have to give the credit. Isn't that right?
Yes, we're not actually able to recover our actual debt because we are required to give an offsetting credit.
But you're using it.
Well, we are recovering an amount of supply-related bad debts in the default service rate, but we're not getting our actual amount.
No, I understand.
And it's not reconciling. I think the critical issue before the court is the total failure of the department to address and talk about the evidence that was presented. And that evidence unequivocally shows that on January 1st, supply-related bad debt was, in fact, removed. And it did it by essentially arguing that the exhibits attached to the settlement were illustrative.
Did you promise to do something in consideration of being able to remove the supply-related bad debt?
No, we just took it out in order to give effect to the default service mechanism in the department's policy statements in 0388. We were adopting what the department had already decided in 0388, and we did it strictly according to the way that the department said we had to do it in 0388, and it's specifically in all of the exhibits. Every other company in Massachusetts has been allowed to implement this mechanism, and if the issue is, and I think it is, did we go ahead and remove supply-related bad debt from distribution rates? The testimony of Mr. LaMontagne clearly demonstrates that we did. And why the department has totally ignored that evidence, the only evidence really in the case, and simply says, well, we think those exhibits may have been illustrative. They're not. They're not illustrative. They are the actual.
When you talk about ignoring the evidence, you mean the evidence submitted at the reconsideration process?
Yes. If the issue was we weren't explicit enough in the language of the settlement, there never would have been any reason for reconsideration. We were either explicit in the settlement or we weren't explicit in the settlement. They opened the record to say, well, maybe, wait a minute, based on everything that happened, maybe you did, in fact, remove supply-related bad debt. We demonstrated unequivocally that we did, in fact, remove supply-related bad debt, and the company should be allowed to implement what the department has already stated on page 4 of the joint appendix is a mechanism that is exactly consistent with its policy directives in 0588, and which is consistent with exactly what our currently effective tariff language is on the recovery of bad debt that went into effect on January 1st, 2006.
Thank you.
Thank you very much, Your Honor.
Mr. Chief Justice Ireland, and may it please the Court, Special Assistant Attorney General David A. Guberman for the Department. NSTAR seeks to overturn the Department's interpretation of two of the Department's own rulings approving two settlement agreements.
No, well, why isn't the question precisely the question that's been posed? Did they or did they not remove the bad debt from the distribution rates in January of 2006?
They did not. They did not, but that is not the question.
Why not?
And I can address either one first.
Well, why don't you address why that isn't the question?
It's not the question because, as the Court explained in the Attorney General against the Department of Public Utilities case in 2009, once a base rate is established, and a base rate is established by using historical data from a test year, it operates prospectively, regardless of the fluctuations in the company's actual experience, until in a subsequent base rate case, the company, following the procedures set out in Chapter 164, Section 94, gains the approval of the Department for a change in the base rate.
And you don't think that the settlement agreement that was approved by the Department isn't an approval of a change in the base rate?
That's the question, Your Honor. Does the second settlement agreement, the 0585 settlement agreement, contain an approval by the Department for a removal of supply-related bad debt from the company's distribution rates?
Your first premise was, or are you not saying that that was an approval of a change in the base rate?
It was an approval.
It was a filing of a base rate filing. There was a settlement. They approved the settlement. Isn't that so?
Yes, they approved the settlement, but the settlement does not, two things, Your Honor. First, the settlement in itself, and it has to be looked in context, and I'll come to that in a moment, does not contain any language approving a removal of supply-related bad debt from the company's distribution rates.
Are you suggesting to me that that issue was not discussed up the yin-yang during the settlement negotiations? It had to have been.
Well, with respect, Your Honor, it need not have been, and it's not in the record, and whether it was discussed or not is irrelevant for this reason. When a company comes in for a general base rate case, which is the hypothetical case contained in Exhibit 1.
That's what this started as.
Which is, well, it didn't start as that. It started as a motion, a joint motion to approve a settlement. And Exhibit 1 says if you don't approve this, if it weren't for this settlement, the company represents is what we would have done. And that, as has been pointed out, contained express language showing that it would have proposed to remove supply-related bad debt from the distribution rates. In a settlement, the parties may agree on the total amount of a rate increase, $30 million instead of $89.3 million, even though they are unable to agree on what the components would be.
But here wasn't just an agreement on the $30 million. That was to go into effect as of May. I didn't see anything in your brief which discussed what the purpose would have been for the distribution rate change that was to go into effect on January 1st of 2006, which was a lessening, a decrease. I didn't see any discussion of that in your papers.
The department's view, and I think there is a reference to it on page 20 of our brief. While the 05 settlement went into effect on January 1, 2006, the $30 million distribution rate increase did not go into effect until May 1, 2006.
But wait a minute, but that's not what the agreement says in paragraph 2.5. Paragraph 2.5 calls for an increase as of May 1 of 2006 of a rate, and calls for a decrease in a rate on January 1 of 2006. It's not just that the agreement itself goes into effect on January 1, 2006.
Yes, Your Honor, but...
And so I'm asking about that
let me put it
diminution in the rate that's to go into effect January 1.
Put it in this context, and we have to go back to the first settlement agreement, the 0388A-F, because that set the framework for what the company had to do in order to remove supply-related bad debt from its distribution rates. And what that said in sections 2.2 and in sections 2.4 were that even though they were going to start collecting supply-related bad debt through basic service rates and not through distribution rates, for rate-making purposes, for accounting purposes, and for all other purposes, supply-related bad debt was going to continue to be treated as part of distribution rate revenue and cost. And then in Section 2.4, it tells what the companies needed to do in order to remove supply-related bad debt from their distribution rate and costs. And what they had to do was to get the approval of the department. The paragraph says, subject to approval by the department in a general base rate proceeding or in some other fashion where the company proposes it.
I must be just not understanding what you're saying, because that seems very circular to me. It seems to me that if this 2005 settlement agreement was to be taken as an approval of the $30 million, that was the change in an upward change in the rate that was to go into effect of May 1. I don't really understand why it wouldn't also be an approval of the distribution rate change that was to go into effect on January 1, 2006, even though it was a lessening. It would seem to me to be an approval as much of one as of the other.
Yes, it is absolutely an approval of both, and I'm sorry if I misunderstood Your Honor's question, but the reason that doesn't help NSTAR is that in order for that to take the supply-related bad debt out of the distribution rate and costs, then it had to be specifically stated in Article 2 or Article 3. Your Honor is shaking her head, but that's the language.
I'm shaking my head because 2.4 that you just referred to doesn't say it has to be specifically stated in something. It just says it has to be approved.
That's 2.4
I know
of the
that.
first.
That is
yeah.
03. That is right.
Yes,
it doesn't say it has to be. It has to be a specific approval in language of that uses the word specific approval of this particular provision.
You're right, and for that we have to look at two sections of the 0585 settlement agreement. The first is 1.5, which is on page 341 of the joint appendix, which says this settlement agreement is intended to resolve only those issues as specified in Article 2 and 3. And then in section, I believe it's 3.2, at pages 359 and 360.
2 has the 2.5 in it, correct?
Yes, but there is nothing in 2.5 that specifically states that supply-related bad debt is.
We're getting right back to whether it has to be specific.
Well, that's what, yes, we are, because that's what 1.5 says, only those issues as specified. And then if Your Honor will turn to pages 359 and 360, in section 3.2, the agreement says that it only has preclusive effect as to those issues, I'm reading from the top of page 360, as to those issues and proceedings that are stated in this settlement agreement as being specifically resolved and terminated by approval of this settlement agreement.
Okay. Let me ask you this, if I could. Assume that that is correct. NSTAR comes forward in 2007 and says, okay, and I'm talking about the motion for reconsideration.
Yes.
They have factual information, and you say that doesn't make it because why?
It doesn't make it for two reasons. The first, which I won't belabor any longer, is that it is simply re-arguing issues that failed to show that there was any specific statement that the settling parties could have agreed to and the department could have approved to remove this item from distribution rates and costs. The second reason is that, in fact, NSTAR continued to apply the distribution rate credit after the settlement went into effect. They say that they did it by mistake.
Well, when you look at, or the department looks at Mr. Lamontagne's testimony and the other exhibits, the department in good faith says, no, it's not there? Is that what you're telling us?
The department is saying two things. One, the department is saying that even if we assume that it was the intention of Mr. Lamontagne and some of his colleagues back in the 05-85 proceeding to remove supply-related bad debt, they never put that in the record, they never put it in the settlement agreement, so that the department was never in a position to decide whether or not that was in the public interest. That's one.
But Mr. Keegan says that it's in the default service tariff.
It's not, Your Honor. What's in the default service tariff, not surprisingly, is a provision to collect supply-related bad debt through basic service. And that's not surprising because that was a requirement of the first settlement, the 03 settlement.
Right.
What is missing is any statement that those costs were to be removed from the distribution side. Remember, as a result of the first settlement, NSTAR, in common with other electric distribution companies, began charging supply-related bad debt on the basic service side, and they provided a credit on the distribution side.
Does the department take the position that fairness would say that you get to collect the bad debt from the supply-related system,
on the basic service side,
and you have to withdraw it out of your general rate base, right?
Yes.
And if you that fairness would be if you've done one, you've drawn it out of your rate base, and you're doing the other, that's what's fair. Would they agree that it is not fair to keep it to get the credit when you've already withdrawn it?
In the context of this case, no, Your Honor, and for this reason. The base rate, which refers to the distribution side of the ledger, so to speak, has a whole number of costs involved. Some may go down, some may go up, but the base rate doesn't change until a change is approved by the department in a subsequent base rate proceeding. And so the question is, in this case, what was the department asked to approve? It's quite conceivable, we don't know, that there were other changes on the distribution side that advantaged NSTAR. And so on a net basis, if ultimate fairness to the ratepayers is that they only, on the distribution side, pay the company's actual costs plus an authorized return on equity, fairness would say we need to have either a general base rate proceeding when all of this can be addressed, or items that are going to be dealt with ad hoc have to be specifically dealt with.
I didn't say it well. I guess this is my point. It seems to me coming out of the 03 agreement is a formula or a system for dealing with this transition. And that is you use the basic service system and you give the credit until there's a general rate filing, and then you withdraw it from the rate base, and then you just continue with the basic service, and you don't need to go anymore with the credit. That's a formula that everybody agrees to, right?
Yeah, I believe so, Your Honor.
And so if in this case, if that is indeed what NSTAR did, I guess I can't figure out why we are asked to decide this, because it seems to me either they did it or they didn't. And that's an accounting. I mean, that's just sort of looking at these numbers and these tariffs and figuring that out. And you are in much better position than we are to figure that out.
Well, they didn't do it, and the department said that they didn't do it. But more than that, the reason I think that we're here is because there was a settlement agreement in 2005 from the 03 case that said how they were to go about removing. And then there was the second settlement agreement that expressly says it only resolves matters that are specifically addressed and said to be resolved and terminated, and supply-related bad debt was not so specifically stated.
Would you just explain then what it is that paragraph 2.5 provides for when it provides for approval of a distribution rate change on January 1, 2006? To what does that refer? What is the department's position on that?
Okay. The department's position is that refers to the changes subject to the department's approval that were shown in Exhibits 3 to 22. And then if one goes to the department's order approving the settlement agreement, one finds that in one paragraph the department approves the settlement agreement, and then in the next paragraph it orders the company to file new tariffs compliant with the order, which is another illustration of the fact that the department, when it was approving the settlement agreement, drew a distinction between the settlement agreement and the tariffs and rates. So in order to comply with the 2003 order, the 2005 settlement of the 03 case, and in order to comply with the terms in paragraphs 1.5 and 3.2 of this very agreement, there needed to be specificity, and there is no specificity.
And I'm sorry to keep you long, but I'm trying to reduce this down to things that I can understand. You said the question is, does the 05-85 agreement contain an approval for removal? My question is, does it contain a removal? And you say no. It neither contains an approval or a removal of these rates.
Yeah, and for at least two reasons. First, because
forget the approval. It doesn't contain a removal.
It does.
What Mr. Keegan and NSTAR has presented is all very interesting, but it doesn't prove that, in fact, these debt charges were removed.
In fact, they continue to provide a distribution credit on account of supply-related bad debt, which is evidence that the supply-related bad debt continued to be part of the distribution rates and costs. There also is evidence that they intended to remove supply-related bad debt from distribution rates and costs, even though contemporaneously they didn't include it in the settlement
There is
agreement.
evidence or there isn't?
There is. There is the after-the-fact testimony from Mr. LaMontagne that was his intent, but the Court's precedents are clear that a party's unexpressed intent is not admissible, much less having weight in understanding what went on. And to conclude, these do have, the Court has to, unless the Department's interpretation of the rulings is contrary to the plain language of the settlement agreement, has to give great weight to the Department's interpretation of the settlement agreement, particularly paragraphs 1.5 and 3.2, as saying that the settlement agreement only resolves what is specifically said to be resolved in the settlement agreement. And the plain language, I say, unambiguously supports that, but at a minimum, the Department's interpretation of that is reasonable, and on that basis, the Department's order should be affirmed. I thank the Court.
Thank you.